accessible for disabled people, commercial facilities like stadiums to be accessible for disabled people. That's the kind of work I was doing for the last 15 years. And the challenge that presented was, when you go to federal court on these types of cases, as you know, we use the common law system, so what would happen is that I would have to memorize all the cases that were in my brief. So if I put together a brief, there'd probably be about 20, like when we were fighting with the aviation industry, the question was, does the ADA cover airlines and airports? Well, Congress never specifically said whether it did or didn't. So what you have to do is you've got to go through and you do all your research, and you got to figure out the applicable cases. And they would be basically, I would say, for every time I go to federal court, there would probably be about 30 cases, sometimes a little bit more, that would be in my brief that I'd have to know backwards and forwards. Now, the challenge would come in is that the other side would file their brief. They probably have 30 cases in their brief that would be on point. And what I can tell you is that when you do this kind of work, nobody cares that you're blind. If you're asking Delta to reform operations and rebuild terminals and airports, they've given their attorney a direct order, which is to not allow you to get past summary disposition. So no one cares that you're disabled or not. I'm on my feet in federal court all the time in my past life. And basically, I sit at a table by myself. They'd have 4 attorneys at the other table. And what would wind up ultimately happening, which was very difficult, is the judge would look to you and say, counsel, in case X, Y, and Z, how do you distinguish that? If you don't know case X, Y, and Z, and you're not able to distinguish it and argue it effectively, you lose. It's over. The judge is going to say you're not prepared. I'm sorry. That's it. Goodbye. And so you take these cases, you either do them right, or you shouldn't touch them, or you shouldn't do them, because the stakes are really high. Just very quick in answering your question about how we do it at the Supreme Court. So being a Supreme Court justice is very interesting as a blind person. I don't want to go on too long, but being a Supreme Court justice as a blind person is very interesting. What happens in my chambers, I have 4 clerks, I have a full-time reader, and a judicial administrator. And what happens is that it's challenging because every month you get what are called 200 OTEs. OTEs are orders to enter. That's the cases that you have to decide if you're going to grant leave on those cases. So what happens is hundreds of cases will come up. Unless one justice flags it, there's 7 of us, if one justice flags it, that case is held for conference, which means that you have to get 4 votes in order to grant leave to the case. But the challenge is that I'm a more kind of liberal judge, and so I'm on a more conservative court. So what happens is that you have a lot of life sentences that you have to review. And if we don't flag it, if no one flags it, the case is automatically denied. So unless someone says, stop this case, it will be sent back down as a denial, and the sentence, we do criminal and civil, but a lot of it's criminal. The sentence will be, there'll be no relief from judgment, and that's it. So I have to memorize, like my clerks are going to send me I insist that we brief every OTE. I want them all. And the reason that I want them all is because it's a lot of work for my clerks, but I want to know that nothing is falling beneath the cracks. Because if you leave it just to your clerks to do that, what's going to happen is they can miss it. And I'm shocked as to how much people can fall through the cracks in our system. If you miss a case, if I miss an OTE deadline, that sentence stands. You cannot go back and get it. So if you miss one deadline, a person could be in prison for life. I'll never see that case again. And that's the end. It's over for that person. That's going to be their life. They're going to spend their time in Jackson Penitentiary for the remainder of their days on this planet. And so what we do very quickly is the cases that we have granted leave to, we do about 10 a month for oral arguments. I commit them all to memory. All the briefs, all the memorandums, everything in those cases I've memorized. And the reason is that for oral arguments, I need to be able to ask, especially for the government, when the prosecution or whoever comes up, I need to go ask them questions. And if I haven't memorized that case, I cannot ask them the questions that I need clarification on during oral arguments. And the most important time is after oral argument, you go in what's called conference. And when you're in conference, you sit around a table with the other 6 justices, and you literally decide the fate of people. And it's up to you to make sure if you aren't prepared, if you don't know those cases, that's it. So I memorize them, and I think being blind is a benefit because it requires you, if you give me a case name, I'm going to know everything about that case. Because I will spend hours and hours and hours not reading it, but just internalizing it, so that I can have a debate or a discussion with you around that table. If you say, what about this point? I can refute that or discuss it with you. If you know the cases, you can do it. If you don't, you're not going to be productive. Other questions, please? Yes?
I have a question. We just came from some films about relationships and dating. Can you talk a little bit about just your experience relating to not only dating but friendship experiences as a young adult on the spectrum?
Yeah, I definitely think it's an interesting topic because right now I'm definitely in a transition period between college and work life where I'm still trying to meet people. But I think also when you ask people for help, like making friends, people assume because you're an LD or you're on the autism spectrum where you don't get social skills. And for me, I really try to explain it to people that it's not that they don't get social skills, it's that they get social anxiety, which is another type of hidden disability. And that some of that is come actually because of other things in the past. So there is a lot of labels of people with autism aren't supposed to understand social skills. And some of that stuff that gets said gets brushed off on people and becomes reality for them. It did for me for a while. I thought it was totally who I am. So I definitely get like socially anxious, so I asked if I could. So sometimes when I ask for help, people will, this is where when you ask for help, it's really important because I will try to make it clear that it's not because I don't understand social skills. Because usually what happens if I freeze up is I'm overanalyzing everything because I'm socially anxious around it because I know that I'm supposed to not be good at it. So I think it's a really something that, that's important. But I think there's a lot of need. People want friends, whether it's somebody and I don't like to be limited to having to be friends or dating somebody who's on the spectrum. There's people who I get along with who are on the spectrum, but I also want to get along with, but the people I want to be with, just like I think anybody wants to be with, is people you have stuff in common with. So sometimes that's people on the spectrum because we have commonalities of experiences or interests, but then sometimes it's not, it's other people too, or even Justice Bernstein, the reason we're friends is we have a lot of things that we share in common, like traveling and other interests, and that's really, I think, what we want to sort of go toward, is that maybe it's more about finding people together by interest if we're trying to work towards things.
Other questions? Oh, yes?
Well, I was a question for Justice Bernstein. Do you feel that people who work with you need, or I mean this is true in all jobs, but need special kinds of training to be more effective in assisting you or assisting the court?
It's a wonderful, wonderful question. So I right now have 3 clerks from the University of Michigan, 1 from Northwestern, my alma mater, but we're going to be starting next year, we're going to be working with Harvard Law School. And what's interesting is that a lot of people are applying. It's quite interesting. We're getting a huge number of applications for clerkships in my chambers over that. It's interesting. The reason why is because if you get to clerk for a blind justice, you get to have tremendous interaction with the judge. That usually doesn't happen. Usually what will happen is most clerks will communicate by email. The judge is going to read, like for example, I get a bench memo and basically, what justices do. I mean, just to kind of clarify, the reason that there's a distinction between justice and judge. Judges are for everything other than the Supreme Court. So in the federal system, you would only refer to justice for the United States Supreme Court. In the state system, you would refer to justice exclusively for the Supreme Court. So anything. That's why people get confused. What's the difference between a judge and a justice? Justice is reserved exclusively for the highest court. So what happens is that when you have a clerk, what takes place is that most other justices at this level don't interact with them that often. They basically say, look, I want a bench memo, write up the bench memo, I want to see what you're thinking, where are you at. They then kind of take the bench memo, digest it, make their comments, send it back to the clerk for revision, and it keeps going back and forth. In my situation, my clerks get much more interaction. So they write their bench memos. After I've read all the different other documents that pertain to the case, I want to read the bench memo, but I also want to see the briefs, because I just want to make sure that I'm getting everything that's in a brief. You know, the attorneys work hard on those briefs, I want to read them. And so what happens is that I look at the briefs, I look at the bench memo, and then after I've internalized it, I bring the clerk into chambers or to my office. And I ask them to, because they make a recommendation, I ask them to justify their position. And then we will sit for hours and go back and forth. And I'm going to say to them, well, what about this? What about that? What are you thinking about this issue? What are you thinking about that? And I can't think of like actual cases, but you know, the cases that you would deal with would be everything from your right to a speedy trial to, I mean, literally every possible thing that you can possibly, termination of parental rights, to literally ineffective assistance of counsel, to, I mean, just, it's crazy because you're going from one to the other. You could literally read, you know, I could literally be reading a bench memo about a murder conviction and, you know, is there ineffective assistance of counsel? And then I could read the next bench memo and it's going to be about termination of parental rights. Then I could go to the next bench memo and it's about two corporations fighting with each other. Then I go to the next memo and it's about drilling in the Great Lakes. Then I go to the next memo and it's about insurance companies fighting with people. It's just, you literally have to go from one thing to another thing to another thing to another thing, and you have to know it. Like, you know, you literally have to teach yourself and know all these areas of law so that you can make a determination as it comes to that. So I think in terms of the training, it's not really about the issue of training. It attracts a certain type of person that would love to have personal hands-on interaction with their justice, whereas for most other clerkship opportunities, they do not get that. You sit in your office, you basically research, you send an email to the judge sends it back to you, and that's it. You don't really get to talk or interact. Here, part of this job is intensive interactions, so a lot of the law schools have asked if they could set up clerkship opportunities, which is surprising because they have to live in Lansing, Michigan, which is our state capital, and it doesn't seem to dissuade them. They really want this opportunity because they want that interaction they otherwise wouldn't get from the other justices.
Thank you.
Other questions? Yes.
I wanted to ask you a question as to when you lost your sight, were you born with this sight or that sight? How, from childhood on, was your education modified, or how was it so that all along the way you had this quality education and were able to get to the point that you got to? Because I work with families at the beginning point, and I'm just curious how it was all along the way.
So the way I see this is I'm also very, very conscious of this all the time. And the funny thing, I don't want to give too many long answers, and I apologize. I hope these answers aren't really too long. This is a really challenging issue. And it's something I'm very sensitive to and very concerned about. 85%, I can only speak to the blind community, 85% of the blind community is currently unemployed. 85%. And that's not because they're not talented, or they don't have ambition, or they don't have incredible abilities to do great things. The reason that 85% is unemployed is solely socioeconomic. I would say it's solely that. I got to go to the Bloomfield Hills Public Schools, one of the best school districts in the country. It's such an economic-driven circumstance. And I think what you have to do is you have to always recognize that every single person has a story. You can never, ever look at two blind people, or two disabled people for that matter, and say, wow, that disabled person's doing it, why can't this other disabled person do it? You have to always respect, always, that people have stories. They have an understanding and appreciation of the world that is driven by their story. that makes them who they are. And I can just tell you unequivocally, if I didn't come from an affluent background, I'll just tell you this right off the bat, I would be part of the 85%. There's absolutely no question. What's different for me? I would be part of that 85%. There's no question about that. That would be unemployed. There are two types of people often in the world. I mean, I'm simplifying it, but I do believe that it's kind of a cognizant way to approach it. You have some people that basically go through life and they know only struggle, hardship, and challenge. You have other people who go through life who don't know hardship or challenge because they have an easier path. But the difference is, and why I work so hard at what I do, is because it's rare that you get both. It's rare that you get a person that has to go through some struggle and hardship and difficulty, but then was born with the financial wherewithal to be able to do what I get to do. I think that's a very, very important distinction that should always be made. The answer to your question about this is that you've got to approach every person in their own individual context and their own individual way. The whole reason I ran for the Supreme Court, when I went through all of this to get into this position, was because there are three things that you should always do. You have to apply the law to the facts. You also have to apply your own personal life experience. Life experience matters. And if you have people who don't have a certain set amount of life experience, they can't understand or make it real. That life experience component, after you apply it to the law and the facts, is an absolutely critical thing in entering into discussions and passing judgment that really affects how people live. So in answer to your question, I think that as you move forward with this, I've been born blind. This has been my life. But I've been born also with the ability to do the things that I get to do, which is not the case for everyone. So I think you need to always respect there are no two disabled people who are ever the same. And I'm going to be very clear about this. No one disabled person can ever speak for another. Ever.
Yes. Folks, we have time for one last question.
Yes, I just was wondering, so you brought the whole issue of like individuality up. So doesn't that's complicated with policy though. Because like how do you account for so many different people, different types of experiences within policy?
Jason?
Well, I think that it's tough because policy is really supposed to deal with, it seems like, people in general, but some of the things that we want to do for people is something that doesn't need to be always done by policy. Some of it is, and like some of the questions you asked earlier, should people change the way they practice things? It's really by showing there is value in having somebody who's blind work for you, or there's value for having this accommodation set up. Not because it's just to help these people, but because if the people who get it get what they need, and they can make huge contributions to society as well. We want to be able to not just be able to move things through policy, which is important still, but we also want to be able to say, this is more than just policy. Some of this is how we interact with each other every day, how we look at it, why people want to do some of the things they want to do. And if we can show that there's people who, like anybody who has the potential to do things, and that they have those things that are offered there, sometimes it would be nice if it didn't have to be policy driven. It was there because people are like, we want to get the most out of you, this is how we can help to get the most out of you. And there will still always be a need for policy, but policy is only the beginning in most cases.
Did you want me to answer that too?
Sure,
I had a feeling you were asking both of us that question.
Yeah.
I had a feeling you were asking how do you apply your personal life experiences to policy as it pertains to constitutional interpretation. So the question is, what you're really asking, I know we're running out of time, but I'll be quick, it's a great question. The question that you're asking is, are you like a strict constructionalist? How do you interpret the Constitution? You know, how do you go about doing that? And I'm just going to pose a question back to you. The Sixth Amendment says that you have, this is a hypothetical, but it might be somewhat more real than you think. I'm allowed to speak about, I'm not allowed to speak about specific cases, but all of our cases are usually covered by the news or television, so I can speak to any case that is, and I can speak to you about a case that is a matter of public record. without indicating how I'm going to rule or where I'm going to go. And I can speak with you about specific issues. I just wanted to make it as a caveat. You just never know who's in your audience. Sixth Amendment says that you have a right to a speedy trial, correct? The Constitution says you have a right to speedy trial, right? What does that mean? What defines a speedy trial? Sixth Amendment says you have an absolute right to a speedy trial. What if you get held? Let me give you a hypothetical. What if you've been charged with a murder? There's no question that you did it. You are charged with a murder. Let me ask you a question. What would you do? I'm just kind of letting you out in terms of when you ask a policy question. How do you approach that? You're on trial for murder, right? The government was slow in getting your case to trial. So let's say the government took over 4 years to get your case to trial, but you languished in prison. Not prison, jail. Jail's worse. You languished in jail for 4 years before your trial came. How would you approach that? The Constitution says you have a right to speedy trial. The challenge for a justice is that the only remedy for violation of speedy trial is your immediate release. So when you ask the question about policy and law and constructionalism, what is your time or your value worth in prison? Did you lose 4 years of your life? What if you were innocent? What's the remedy? And you spent all that time. You have to balance the Constitution, community, but most importantly, you have to think about what impact does that have. What if you got a prosecutor could issue up charges today against you? You go to jail, right? Let's say you were accused of abuse of a child. It's pretty easy. Prosecutor writes up some charges, you're gone. You're off in jail. You're a flight risk. You're going to be denied bail on that, right? Do you let the murderer go free, even though you know it could be a high risk to the community, to send a message that there's a prejudice to the person by making them go to jail before trial? Or do you allow for these crimes to continue and say, oh, it's not a big deal, it's not a big deal, it's not a big deal, no matter how serious it is, and then allow for the government to allow you to be incarcerated for a very long period of time without forcing them to make you come to trial? I'm going to end by saying this. These are the kind of issues or challenges that we have to decide on a daily basis. Thank you for this opportunity.